it has now, with time, become very important, especially for upcoming businesses and startups. It's the market is highly competitive these days, and there are many new brands and new companies taking over the market, and they are mostly overlapping each other. The business segments are almost same, and it has now become very, very important for the Indian intellectual property rights regime to protect their trademark law. For that purpose, the legislature has already passed a very good act, which is the 1999 Act of Trademarks Act, and it extends wide range of protection to the trademark holders in the industry, and basically it actually differentiates between the products in the market, in the same category products in the market. Business holders can sit back and relax once they get their trademarks registered, that nobody else will take undue advantage of copying their trademark and selling their products under their name, selling wrong products under their name. Because the Trademarks Act is very wide, it has got quite strict rules and regulations which extend the protection to the business holders, to the trademark holders. Just that people, I believe, today need to be a little more vigilant about their trademarks, and they need more of awareness. They should get their trademarks registered on time. The moment they start using a trademark, they should not wait for any infringement to take place, and they should just go for filing their applications for registration of trademark. And for that, it's very important that lawyers and trademark attorneys especially should know about how to apply and where to apply, and how they can help their clients who are companies and who are businesses, or new businesses or old businesses, who wish to get their trademarks registered. So trademarks are not only important within India, the law itself is also important on international level, because many times some brands which have not come to India but they have a trademark registered in India may require some kind of protection in our country, or maybe some Indian business which is not registered outside but it sells its products, and if somebody is infringing their trademark in other country, then also trademark law becomes very important. So today I have prepared a brief, I won't say brief because it's quite huge, because it has got many slides. Basically, it shows how a trademark can get registered and what exactly is a trademark, and what is the importance of trademark for today's business persons and business owners. So I'll be sharing that content with you. Slides visible? Are the slides visible to all?
Yes, ma'am.
Okay, so first I just want to ask any of you who would like to answer. What comes in your mind when you hear the word Domino's? Like, how do you picture Domino's? Any one of you can answer. Like, if I say I'm ordering a Domino's pizza, then what comes in your mind?
Ma'am, the logo.
Yeah, you need logo.
Can anyone describe the logo without Googling?
Two dots and one dots. Two dots in one box and one dot in another box.
Yes, and the boxes are different in color, right?
Blue and red color.
One is blue and one is red. And how is the Domino's word written?
With post offices.
Is it blue or red? The word
Blue.
Domino's is blue or red?
It's blue.
Blue. And there's an apostrophe comma, right? Before the S.
Yes.
So, see, the moment I said Domino's, all these pictures come into your mind and you can actually connect yourself to that trademark which is registered for Domino's. Can you connect this mark with any other brand of pizza? Is there any brand which can copy this mark, or a brand which shows like which the name and the style of the word is just as similar as Domino's? Is there anything in the market?
No,
No,
ma'am.
No, no. So when you go to a pizza shop and let's assume that there are two shops, on one the same mark is there, the Domino's in big words, and the other one is, let's say, Promino's, and it's the same style, same word, same expression. So which one would you prefer taking your friends to?
Domino's.
Domino's.
Why?
Because it is a well-known brand.
Yes. And what do you connect with well-known, being well-known?
The quality.
Exactly. Exactly. So you are a loyal customer of Domino's. You are a consumer who only want Domino's pizza in the market because of the quality assurance given by Domino's and the brand which has been there for so long that you can actually reconnect yourself to the brand by just thinking about it, by just taking its name. This is the effect of a trademark. And this is earned in a span of time. It doesn't come just after your registration. You have to make a market for yourself. You develop your brand. You enjoy the confidence of your consumers, your customers. You ensure that you are going to give them quality services or quality products. Then only you can grab the attention of the market, and you can make sure that your customers do not choose any other brand over your brand. So what will happen in this case is that since Domino's is a registered trademark of Domino's, if tomorrow Promino's is opened, then Domino's can immediately file a suit in the court for infringement of their trademark. Why? Because Promino's sounds like Domino's and it looks like Domino's. So it is, first of all, it is not going to be allowed by the trademark registry to get registered. Secondly, even if they illegally use it, they will be held liable under infringement laws under the Trademark Act, and immediately an injunction order can be sought by the Domino's from the court. Okay. So this is the effect of a trademark. This is why trademark is very important for any business. So let's start with the slides now. Today we are going to discuss trademark under the trademarks. So first we'll look at the general definition of trademarks. Then we'll go for importance of the trademark for businesses. We will go through the procedure of the registration, and we will go through with some of the landmark cases which are interesting. And I would suggest that after the presentation is over, after this session is over, one must go and revise these case laws so that it becomes more clear in their mind as to how exactly the courts deal with the matters related to trademark. Okay. So let's start. What is a trademark? A trademark is a recognizable sign, design, or expression that distinguishes products or services of a particular source from those of others. They are crucial in commerce, ensuring brand identity and protecting businesses' intellectual property rights. Effective trademarks can take various forms such as words, logos, sounds, and even colors. Now, this is interesting. A trademark can also be a sound. How many of you have heard that sound of Intel? Intel, when you close your, I'm sure Mr. Sahai, if Mr. Sahai is listening to me, he
Yes,
will
yes.
know.
I know.
Intel has a music when you shut down your computer.
Yeah.
Right? So that small part of music is actually a registered trademark of Intel. Okay. So trademark can also be a sound. That sound cannot be used by any other company, any other software company. Okay. So trademarks can be words like Ford. You have seen Ford cars. That Ford word is also a trademark. Trademark can be logos, like you see right in the screen. Moment you hear Coca-Cola, you just start. Coca-Cola is such an old brand that you don't even need to think about it. You will just get it in your mind that Coca-Cola has to be written in these kind of fonts, and it has to be white in color, and Coca-Cola, in between there is a dash. So Coca-Cola is a logo. Okay. So words, sounds, logos, colors, they all can be categorized under the heading of trademarks, and business brands and business persons can go and get them registered if they are meeting the criteria. Okay. Some of the most well-known trademarks include the Coca-Cola logo with scheme, Nike's iconic swoosh. You all must have seen that, Nike's swoosh. Logo representing motion and speed. Apple's minimalist bitten apple logo symbolizing innovation and quality. Obviously, Apple, nobody can forget. Apple, that half-eaten apple is a trademark of Apple, and it symbolizes innovation and quality. So these are some well-known trademarks which are already there in the industry. And the moment someone infringes these trademarks, it's very difficult for them to get away with, because of the strong identity they hold in the market. Okay. So let's now see trademark under the Trademarks Act. With a dynamic and competitive commercial landscape around, trademarks hold a particularly crucial role in the IPR regime. I've already told you how competitive the market is today. Everybody, products today in today's market are overlapping each other, and everybody wants to, compete with each other, and everybody wants to win the race. So that's why now it has become more difficult to protect and preserve the trademarks which a brand holds, which a brand owns. So the Act of 1999 offers a comprehensive legal framework for registering, protecting, and enforcing trademarks. The Act represents a monumental legislative achievement in India's robust intellectual property system development. It embodies a modern approach to trademark protection and management, reflecting the evolving nature of commerce and the critical need to safeguard brand identities in a globalized market. The Act ensures that businesses can thrive in a competitive environment while maintaining the integrity of their unique symbols and marks. Now, in order to get your trademark registered, you also have to ensure that your mark is a unique one. It has to have some kind of innovation. It has to be something which is not seen earlier. When you go for registration of a trademark, you have to make sure that your mark should not be sounding or looking similar to any of the mark which is already there in the regime. So that's the first step which you have to ensure. We'll come to the steps for registration later on. But it is very important that any business owner who has come up with an idea in his mind about a business also comes up with a trademark which is very unique and distinctive in nature. It should not be there already in the regime. So let's see what is the definition of trademark under the Act. As per section 2ZB, 2 subclause ZB, a trademark is a mark capable of being represented graphically and which is capable of distinguishing the goods or services of one person from those of others, and may include the shape of goods, their packaging, and combination of colors. So basically, the most important element of any trademark is that it should be able to distinguish the mark from the others in the industry. If it's not distinguishing, or if it is creating any kind of deception or confusion in the general public, then it is very unlikely that the trademark can get a registration. Because the first criteria which you have to meet in order to get your trademark registered is that your mark should be different, it should be distinguishable. So even as per this definition, the mark has to be distinguished, and it can be in the form of packaging of the good, the shape of the good, and the combination of colors. Okay, so that is very unique, and the business owner must ensure that he comes up with some, either he has a team which can make a trademark for him, or he himself comes up with something in mind which was never there in existence. Now, this definition captures the essence of a trademark's role in commerce. It highlights the necessity for a mark to be both visually identifiable and distinct enough to differentiate one entity's products or services from another's. Okay. So now let's see the importance of trademark for businesses. Is everything clear till now? I'm assuming it is.
Yes.
Anyways, we have a Q&A session after the seminar is over. So, importance of a trademark for businesses. The importance of having trademark transcends the mere act of registering a logo or name. It is an essential component of a comprehensive brand strategy. A trademark serves as the cornerstone of a brand's identity. It visually and intellectually represents a company's values, quality, and reputation. As I said in the very beginning, when you hear about Domino's, the mark which comes in your mind connects you to the quality. So, over a period of time, Domino's has earned this kind of reputation and goodwill, which is in the form of a trademark, which is also assignable, and Domino's can actually provide franchisees, which you already know that there are different franchisees of Domino's. So those franchisee holders can also use Domino's outside their shops. So this basically intellectual property is a property which can be transferable, which is also transferable, but provided the conditions are met and provided a valid assignment procedure has been executed between the parties. So now, in a saturated market, a distinctive trademark acts as a beacon, guiding consumers towards a trusted source. The ability to instantly recognize a brand through its trademark fosters consumer loyalty and trust, which are indispensable assets in building a sustainable business. This recognition converts into consumer preference, driving repeat purchases and enhancing brand equity. So you will see a lot of athletes in the market. They promote the brand Nike. And also, if you think about Nike, the first thing that comes up in your mind is that apart from being costlier than the other products in the market, it also ensures the quality. Now, a t-shirt bought from Nike and a t-shirt bought from a local brand will definitely have quality differences, and obviously a person who can afford the brand will always go for the branded product, which is the Nike. So when you think about a Nike t-shirt, what comes in your mind is that ये तो अच्छा ही होगा 101%, ये तो लंबा चलेगा, ये durable होगा, it is going to be a very good quality product, and it is been made of a very good this thing. The quality, the cloth which has been used is of high quality, and it is going to be long lasting. So this is because Nike has earned a name for itself in the market, and this is because Nike has created a brand and created a trademark for itself. A trademark is very important for any brand because it brings goodwill, it brings money, it brings financial strength, it brings consumer trust, it brings consumer loyalty, and it brings repeated purchase. If one of your Nike, if you are one who always prefers branded clothes or branded sportswear, if one of your Nike t-shirt is now worn out, you will definitely go in the market and buy another Nike t-shirt. You will not go for any other brand, but only for Nike, because your experience with Nike was amazing and you always want to buy Nike. So because of this strength which Nike has given to its consumers, people are going to prefer the t-shirt which is of Nike, right? So this is what the importance of trademark is for the business holders. Now, securing a trademark confers exclusive rights to the mark's owner, ensuring that only they can use it in connection with their goods and services. This legal protection is crucial in an environment where brand imitation and counterfeiting are rampant. Now, a person who has used a Nike t-shirt will also understand the difference between a Nike t-shirt and a counterfeited product. Like I have done many cases where a very prominent brand in the industry of, I won't name it because the cases are still pending, a very prominent brand in the industry is which is selling off automobile parts. So basically their parts were counterfeited in a local market. There's some disturbance, I think. Yeah. There's a company which is dealing in automobile parts, and those parts are being counterfeited by some local vendors, a group of local vendors. They all were selling off the counterfeited products, and they have stolen the marks from somewhere. They have just created the marks of that brand, and they just stick those marks on the products, and they were selling off. So there was one raid. Somebody got to know about it and informed the police, and there was a proper raid which took place, and then police went and inspected the whole area, and several products which were counterfeited were found from that area, from that whole market in Delhi. And those criminal cases are still pending under the Trademarks Act. So they are infringement cases, and they are still pending under the Trademarks Act.
Ma'am, I
So
have query related to raid.
yes, ask. Please tell me.
Ma'am, let's suppose our mark is registered with as a device mark, right, ma'am? And the opponent is using, ma'am, same mark and same logo, right,
Yes.
ma'am? And we have applied for copyright, but till date our certificate is not issued. So do we have right to file a civil suit?
Yes, you have, because you are already in the market and you've already started using the mark. But yes, we will also see whose mark is more prominent and whose brand is bigger
Ma'am,
than the other
ma'am,
one.
we are the prior user, and opponent just file their logo at a initial stage, and we have using our brand from last 3 to 4 years, right, ma'am? And now we have applied for copyright registration so that we can file a raid against the other opponent party. But
Yes,
ma'am, I have query for this. My copyright is in process, right, ma'am?
that's
So
okay. That's okay.
do
What's
I
your
have
name?
the right, ma'am? Rohan
What's your
Malhotra.
Rohan. See, what happens is, it's not important that your application is in process. What's important is that when have you started using the mark, and how how big your market has become, how you are ruling the public domain. Like every person, how many, basically it will depend on the reach, how many consumers you have reached to, and how many people can actually identify your mark or your copyright, that it is yours. So when it comes to the question of registration, if your process is still there but you have applied for it before that the other mark, then you will get a favorable order from the court, because the other mark came later on, and their application was also after your application was filed. In such cases, the court will see whose application was filed prior to the other one, and who is in the market before the other one came in the market. Okay.
Ma'am, let's suppose my partner had deceived with me, right, ma'am? I am doing my business from last 3 to 4 years. For example, in a pharmaceutical field, ma'am, right, ma'am? And my brand is registered in class 35 as a third party manufacturing firm. So we have we have two partners now. We separated we are separated now. So what my partner does, he uses name. No doubt, my name and his name is different, but the logo which he is using, it's quite similar to my logo. So do I have right to file a raid application?
See, in this case, first you have to see what was there in your partnership deal when you started the business. Okay. You must have defined the ownership of intellectual property rights at that time. if you had decided that any of the partner can use the intellectual property rights in future individually, then you won't be able to do anything. But if it was decided in the partnership deed that the intellectual property rights related to the partnership will only be exclusively used for only for this partnership firm, then you obviously hold a right to file a suit or maybe for inspection of whatever products the other friend of yours is counterfeiting. Okay, Rohan? So let's come to the, am I audible?
Yes, ma'am.
Yes,
Yes, ma'am. Yes, ma'am. You are audible.
Rohan,
Yes,
have I answered your query?
Yes, ma'am. Yes, thank you.
Okay, let's go ahead then.
Thank you, madam. Hello,
Yes, yes. So
madam.
the
Thank you.
next, you're welcome. You're welcome. So the next slide is importance of a trademark for business. Trademarks play a vital role in protecting consumers by ensuring that they can accurately identify the origin of goods and services, preventing confusion and deception in the marketplace, allowing consumers to make informed purchasing decisions. Trademarks uphold market integrity and foster consumer confidence. This is again a repetition of what I've already told you, and I'm sure you must have by now you have got the concept. This protection maintains a fair and competitive marketplace. So it differentiates a brand from its competitors, helping to establish a unique market position. This differentiation is particularly crucial in industries where products or services are homogeneous. A distinctive trademark allows a brand to compete on the basis of its identity and reputation rather than solely on price or functionality. As I said, even if Nike or some other brand, sports brand, which is costlier than the other ones in the market, but one will always go for Nike because they have a preference and they have a quality guarantee given by the brand. So even if it is higher in cost, the person who is loyal to the brand will always buy that brand and nothing else. This unique positioning can lead to increased market share and profitability. Trademarks are essential for businesses seeking to expand beyond their domestic markets. International trademark protection facilitated by treaties such as the Madrid Protocol allows companies to secure their brand identity in multiple jurisdictions. So there are some treaties in place which we will not cover today, but in the next upcoming classes, which also grant cross-border trademark protection to the brands. And this way, a brand can keep their trademark protected even in other countries, not just in India. So this global protection is critical for maintaining a consistent brand image and preventing infringement in foreign market. Now coming to the registration process. Before we start the registration process, the
So
first
before,
step.
do we have any particular requirement that trademark, suppose anyone owns a business, okay, and they should have any particular requirement or guideline to follow before the registration, or?
Yes. So I'm coming to that only. Now,
Sure.
before you start the process of registration, before even the idea of getting your trademark registered in your mind comes, you have to ascertain few of the things which I'm going to tell you now. Ascertain the availability of the intended trademark. Okay. Ensure that the chosen trademark adheres to the stipulations outlined in the Trademarks Act of 1999. A trademark must possess distinctiveness, refrain from being descriptive, and refrain from bearing resemblance to any pre-existing registered trademarks. So basically, you have to make sure that the mark which is there in your mind, let's call it mark before it gets registered as trademark. The mark which is there in your mind should be something which is unique, something which is not there in the market already, and something which is not really descriptive of your services or your products. Like if you are, let's say, you are giving dry clean services, you can't name it as something like something very direct, like dry and clean. That can't be a trademark, because that is completely descriptive of what exactly you are offering to the consumers. So your trademark act bars some of the marks from getting registered as a trademark, and that one of the restrictions in the trademark act is that it should not be descriptive. Like if you're reading it, it should not give you a direct idea that this must be something related to dry cleaning. Like on the screen you can see Starbucks. When you hear Starbucks or you see Starbucks, what comes in your mind is coffee. I agree, but Starbucks, if it was something else, it would have never come into your thought that it will be a coffee brand. It will be a cafe which serves coffee. No, it won't, because Starbucks has got nothing to do with, I mean, not directly anything to do with coffee. So that's why it's a valid trademark. But if something which is clearly showing that this is what the brand is going to offer us, then that kind of a word can't be registered as a trademark. Secondly, your mark which is there in your mind has to be very, very distinctive. The color combination and the alphabets and the fonts used in the mark should not look like, it should not be deceptive, and it should not look like it is similar to some other brand in the market, in the same products, in the same range. Even if the class of products is different, it should still not look like the same brand which is there in existence. For example, if let's say Agarwal sweets, okay, so it's a well-known trademark. If somebody is just cutting off one of the G's from the Agarwal and saying that no, I'm a different Agarwal, that's not possible, because it's clearly giving an indication that it is an Agarwal sweets. So it can't be similar, and the font and the color and the way of writing, way it sounds should not be similar. Like I said, Domino's and Prominos sounds quite similar. Even if you don't see the mark, still you will feel that Prominos must be something related to Domino's, or maybe it is also a brand which has been a new brand opened by Domino's, hai na? So that's why your mark should not be similar to any other mark in the industry, and it should be a unique, and it should not create any kind of deception in the mind of the general public. So the main step, which the first step which is there, is that you have to make sure that your mark is not available already in the market, and it is distinctive in nature, and it refrains from being descriptive, and it refrains from bearing resemblance to any pre-existing registered trademarks. Okay, it has to possess the capability to differentiate the goods or services it represents from those offered by others. Then, undertaking a comprehensive search of existing trademarks is necessary to preempt any potential conflicts during the registration process. Such a search can be conducted through the Trademark Electronic Search System, which is also called as TESS, provided by the Government of India. Now, you should not waste your time because the registration procedure is long. It takes time for a trademark to get registered. It takes almost 2 years to get a registration certificate, and it's a long procedure. There are various phases in that procedure. So in order to just cross it in one go, you should first start by making a search on the website of the provided by the Government of India by the way of TESS, Trademark Electronic Search System. You should type all the keywords which you are going to use for your mark. You should check whether any similar mark is there or not. If there is any similar mark, then you should make some suitable changes in your mark, so that tomorrow you should not face any conflicts, and you should not face any notice of opposition from the other brand, or maybe you may also get a negative response from the register of trademark. So to avoid these kind of hurdles, you should first make a search and see whether anything similar to your mark in the mind is not there, and then you go ahead with the registration process. Okay.
So Paromita, suppose anyone is opening their own venture or company. Okay. So the first process is to register the company, followed by the trademark registration.
Yes. It is very important since the beginning that you get your trademark registered. And even if, as Rohan just pointed out, that his copyright has been applied but it's not been registered, so even if you're not getting the registration in hand immediately, but you should at least keep your application submitted, because it takes time for the registration. You enter the market, you get the trademark registered so that your brand is protected. Tomorrow if somebody else is infringing, you can show the court that, see, I had already applied in the so and so year, and that means I'm already, see, once you apply for a trademark, you don't even have to show that you are using the mark or not. It belongs to you because you have already applied it. Moment you apply for a trademark, you earn a bona fide in the eyes of the court, that no, if he or she has applied for the registration, that means they are the genuine holders. Now there's a difference. You must have observed that if it's a registered trademark, then there is a small r written inside a circle with that mark, if it's a registered mark.
Yes, ma'am.
But till the time your mark is not registered, a lot of brands use TM because it's not registered. But by writing TM, it portrays that it has applied for the trademark, and soon they will get it. Because see, in India, a lot of hurdles are there in the procedure. There are several applications pending, and it takes time for the registrar to dispose of all the applications. So in order to get a upper hand in the upcoming litigation, you should always keep yourself safe by at least applying. Okay, so the step number one, it's a 7 steps procedure for application of a application for registration of a trademark. The first step is trademark search, as I've already explained it to you, that you have to first search in the system and see whether there's any other mark or not in existence, and you should accordingly amend your mark in a way that you don't find any difficulties in the future to get it registered. Step number 2 is filing
No,
of your.
I am so sorry. I just wanted to ask, say example, recently I am NSC certified now, and I have a plan to register a venture for myself so that I can offer my services to others. Okay. So if so, and then I was also working with one of my friend to identify a logo. Okay. So now my question is that first I should register the company, then I have to go for the trademark, or both the process should go in parallel?
No, both the process can go in parallel. In fact, I would suggest that you get the trademark registered in your name individually. If the company is not in existence, you can yourself also apply for the mark to be used in future in your name. Like, you don't necessarily need a company to be there. Individually, you can get the trademark registered in your name, so you can apply
Ma'am,
today.
sorry,
And
ma'am, I have one query related to individual registration.
yes,
As you are saying that if my company is not registered, but I have I have applied for a mark in my own name, individual name, right, ma'am? But my query is, do I have right to sell that brand as an individual? Because if in future my brand gets infringed, right, ma'am? So I don't have any bill regarding to evidence regarding to that brand. So do I have right to file some a suit against the opponent?
yes, why not? If individually you are going to be the proprietor, or you are going to be the director of the company, let's say, okay, even if you are not the director or not the proprietor, individually you want to use that trademark to sell some kind of products. Let's say you want to sell chalk or chalk duster, okay, under that name, under that trademark. Individually, if you are going to sell them in the market, it can get you a right to file a suit against someone who is infringing that mark. You don't need to be necessarily a company to sue someone, because if you get a trademark registered in your name individually also, then also you become the owner of that trademark. Being the owner of that trademark, you get a right to sue the other person who is infringing your mark. Now you are getting confused between a company's name and a trademark. Okay, there's a difference. Company's name can be different and the trademark can be different. doesn't mean that the company and the trademark is the same name, don't have to be the same. We have to just check that in whose name the trademark was registered. Let's say if Mr. Anand Sahai is tomorrow he plans to get the company registered, but today he wants to start selling off the products in the market. Okay, so he can do it under the trademark individually. Okay.
Okay, ma'am.
Sorry to interrupt, ma'am. I have a question. Like
Yes.
you said, Agarwal Sweets. So we get to know that it is a sweet shop by its name. So it is descriptive in nature. So how can it be registered?
Agarwal is not descriptive. Now we understand it is descriptive because there are so many Agarwal sweets. We know that Agarwal is connected to sweet shop only, but Agarwal is just a surname. It's not descriptive.
Ma'am, it's Agarwal Sweets.
Yes, Agarwal sweets. But
Yes.
Agarwal, the term Agarwal is the trademark. The sweets is not trademark. And the way Agarwal sweets is written together. Only sweets is not the trademark. Agarwal sweets is the trademark. So if you are using one word which is completely descriptive, like I said, dry and clean,
Yes, ma'am.
it is completely descriptive. In Agarwal sweets, Agarwal is not descriptive. Okay. So this kind of mark can be registered. And especially it has got preference in the registration process because it is quite a well-known brand and you don't even need to think twice before assuming that it's a sweet shop because it's very old in the market.
Okay, ma'am. And ma'am, Make My Trip, it's a travel agency. So we get to know that this company makes trip. So this is
Yes.
also descriptive, very descriptive.
Yes. It is descriptive. But if you see the way Make My Trip has been written, they have distinguished it. They have said that it is not a very generic term. It is not a very something which anyone can use. The way they have written Make My Trip, they have probably convinced the registry that Make My Trip is not a generic word and it's not a descriptive word because they have made it so stylish and the kind of fonts which have been used are completely different. So it is all it depends upon how unique your mark is. Okay. It should not be something which is descriptive also and which is just written for the sake of writing it.
Okay, ma'am.
Okay. Similarly, like Make My Trip, there are many other companies whose marks are descriptive, but they have chosen for the innovative part. They have probably written the words in a manner that no other company will ever be able to write it in that manner, some very innovative manner. Okay.
Okay, ma'am. Thank you.
Yeah. So where were we? Mr. Sahai, have I answered your query?
Yes, you did. So we was on the process what need to be done for.
Okay. So then for filing of a trademark application, you have to first search whether there's a mark already there or not, and then you have to apply for the mark. For application, you need to give the details like personal particulars of individual or entity seeking trademark registration. As I just said, you can get it registered individually as well. Then the entity seeking trademark registration, like a company or a firm, like name, address, and nationality. If it's a corporate entity, then company's name, registered address, location, and incorporation specifics. These have to be provided in the application. Then you have to, step 2 is trademark filing. A lucid description of the brand name, logo, design, or slogan alongside the goods and services intended for trademarking. There's a term called priority claim. We will not go into too much of details today. We will see this in the other classes. The priority claim provision within trademark registration allows applicants to leverage previously filed trademark applications in other countries to establish an earlier filing date for their trademark. By claiming priority, applicants can expedite the registration process and secure priority rights over similar trademarks filed by others. Then we come to step number 3, which is trademark examination. Now, right after your application gets filed, there's an examination process which is done by the trademark registry. And during the trademark examination process, trademark offices utilize the Vienna classification. This also I will explain in the other classes what exactly is Vienna classification, to systematically analyze and compare trademarks based on their graphical representations. As somebody just asked me about that make my trip question. So here is your answer, that basically a Vienna classification, whatever is there under the Vienna classification, those criterias are looked at while allowing any of the applications for trademark registration. And the officers actually analyze the mark, the way it has been written, the innovative part of that mark, the graphical representations, etc., in order to pass it on as a trademark. So the application undergoes meticulous examination by registrar, who subsequently prepares a written examination report. Within 30 days of receipt of this examination report, the applicant is furnished with a copy of this report, wherein the registrar outlines any potential grounds for refusal or conditional acceptance of the application, accompanied by supporting documentation. So within 30 days of your application, you will receive an examination report, which will provide you the objections of the registry, which it might raise if it feels that your mark is not that easy to get registered, and it will come up with the objections. And the applicant has to file a response within 30 days, presenting all defenses and evidence countering the objections raised by the trademark office. Now, this is a very important step. When you receive the examination report, you have to file a response within 30 days. Otherwise, your application can become invalid. And you have to provide in detail as to how you are meeting the criteria, and you have to oppose the views of the examiner. You have to write why your mark is distinctive in nature, and why it is not going to create any deception in the mind of the general public, and why it deserves to get registered. So within 30 days, you have to file this response. Otherwise, your application will become invalid. Step number 4 is trademark objection. After applicant's response to the examination report, the examiner reserves the right to convene a hearing if deemed necessary due to any dissatisfaction with the provided reply. If the registrar is not satisfied with your reply, he will give you a hearing. He will call you for a hearing in person, and he will actually listen to you why your mark is not up to the mark and it should not get registered, and why you think it should get registered. So proper, like just like we lawyers go to court and we present our cases, just like that you get a hearing. But this hearing is not as a matter of right. You might not even get a registration, might not even get a hearing if the examiner is damn sure that your mark is a imitation of some other mark in the market, and you deserve a rejection. Okay, so the examiner reserves the right to convene a hearing if deemed necessary due to any dissatisfaction with the provided reply, or if the response fails to address the objections outlined in the report adequately. Following the hearing, should the examiner find the response satisfactory, they may proceed to accept the mark, facilitating its publication in the trademark journal. However, if any objection persists, the application may face refusal by the examiner. Now, after the examiner is satisfied with the response which you have given for in favor of your mark, he will publish it in the trademark journal, which comes up in every 4 months, and it has to be checked from time to time, because all the other third parties which are already there in the market will have a bird's eye view on the trademark journal, so that they can check whether anything similar to their mark is coming up in the market or not, and immediately they will come and file a notice of objection. So that's why for 4 months you have to wait for the mark being published in the trademark journal. And if there is any third party which wants to raise any objection apart from the examination report which the examiners are already raised, then it can be given a chance to do that. So step number 5 is trademark publication. After acceptance of the application by the examiner, it shall be published in the trademark journal for a duration of 4 months. This publication serves the purpose of providing visibility to interested third parties, allowing them to review the accepted applications. So the third parties will get to know that this is a mark which has been accepted by the registry. So if they feel that registry has missed out on something, and registry has not considered the fact that their mark is already in place, then looking at that trademark journal, they can come up with the objections. They can, I'm talking about the users who are already there in the market. Okay, so usually what happens in the IPR law firms is that there are certain departments, and there are certain individuals who are only appointed for looking at the trademark journals from time to time. They give a detailed they go through the trademark journals in every time they are published, and they go through all the marks, and they see whether any of their clients mark is going to be infringed or not. Then immediately they inform their clients that, see, this mark has been accepted and it is in the process of registration. Do you want us to file a notice of objection? If yes, you let us know, we will do the formalities. So a lot of IPR law firms have their own departments to do only this kind of an activity. Okay. So this publication serves the purpose of providing visibility to interested third parties, allowing them to review the accepted applications and potentially file oppositions if deemed necessary. The Trademark Journal undergoes weekly updates with newly accepted trademark applications being advertised every Monday. Okay, so every Monday this journal comes up, and it's a weekly procedure, and interested parties may go through that journal and come up with their objections. Step number 6 is trademark opposition. So within a time frame of 4 months following the publication of the application, any aggrieved party holds the right to submit a notice of opposition using form TMO. As I said, the marks remain in the trademark journal for 4 months. So the parties who are going to object to it also have 4 months time in their hands to file any notice of objection. So a notice of opposition effectively suspends the registration process, triggering legal procedure mandated by the Trademarks Act of 1999. To proceed with the registration of the contested mark, the applicant is obliged to navigate through various legal steps, including filing a counter statement and presenting supporting evidence. In certain instances, a hearing may also be convened to address the opposition. Once again, your mark is at the level of examination, because the other party has come and filed a notice of opposition, and once again you have to file documents in support of your mark, and you have to come up for a hearing, and you have to file a counter statement to the notice of opposition by justifying why your mark deserves the registration and how it is not going to create any deceptive situation in future if somebody is comparing the mark of the opposite party and your mark. Okay. So step number 7 is trademark registration. If you win in the procedure of the notice of opposition, then your trademark gets registered. Provided the opposition is resolved favorably, the applicant will be granted the registration certificate. In instances where no opposition is lodged, or if any filed opposition is deemed baseless, an auto-generated registration certificate will be issued to the applicant by the Trademark Registry Office within 7 days following the conclusion of the 4-month publication period. This certificate must be renewed every 10 years to maintain its validity. Now, the certificate which is issued also requires a renewal. In every 10 years, you have to get it renewed by paying the requisite fees, and you have to get a renewed certificate for yourself. Like, there's an expiry date of this registration certificate as well. So let's come to the landmark cases. There are few. First one is the Coca-Cola Company versus Bisleri International Private Limited. So it's a very interesting case where Coca-Cola acquired the trademark rights for Maaza from Bisleri in 1993, along with a deed of assignment for $1 million. So there was a deed of assignment in which Coca-Cola had bought the trademark rights on Maaza. You all must be aware about Maaza. It's a mango drink. So it was of Bisleri, and Coca-Cola bought it in 1993. But a dispute arose when Bisleri started exporting Maaza to Turkey, claiming that the agreement with Coca-Cola was specific to India only. As a result, Coca-Cola filed a suit in Delhi High Court for trademark infringement and passing off. The moment the mark Maaza got assigned to Coca-Cola, it became Coca-Cola's intellectual property, and therefore it filed a suit in the Delhi High Court saying that how can Bisleri now export Maaza to Turkey when it is already assigned the mark to Coca-Cola. So the issues which were to be decided by the court were whether there's a trademark infringement or passing off. Is Coca-Cola entitled to a permanent injunction? So these questions were answered by the court by saying that court upheld the validity of the deed of assignment, affirming that the defendant had no right to cancel it. As the rightful owner of the trademark, Coca-Cola was granted the exclusive global rights to use Maaza. The High Court issued an interim injunction against the defendants' use of Maaza, finding their actions to be in breach of the contract. This ruling confirmed Coca-Cola's rights as the registered proprietor of the trademark. So the next case is Cadila Healthcare versus Pharmaceutical. This is a case, a watershed moment in the history of unregistered trademark, passing off. Passing off action is possible in the case of unregistered trademarks. Someone just asked me a mark, whether it's, if it's registered, can it be protected or not by the way, by way of proving the use. So yes, it can be protected by filing a suit for passing off. The passing off action is based on premise that no one has the right to portray his products as someone else's goods. To put it another way, a man is not allowed to sell his goods or services under the guise of being that of another person. Both the appellant and the respondent were pharmaceutical companies had taken over the Cadila Group's business after it was restructured under the Companies Act. Now, the right to use the word Cadila was given to both the firms. The appellant company first developed a drug to treat cerebral malaria under the brand name Falsigo, and was given permission to market it across India by the Drugs Controller of India in 1996. The respondent was also given permission to market drugs for cerebral malaria under the name of Falsitab in 1997. The Supreme Court considered a number of factors, including the legibility of doctors' prescriptions, the risk of unintentional misunderstanding due to misleading similarities, and the need for vigilance when dealing with medications that treat the same condition but have different composition. Okay, so the definition of a reasonable ordinary person was described as someone with a poor memory and average intelligence. Even though both medications are Schedule L drugs, which means they can only be purchased with a prescription in hospitals and clinics, the court recognized that there may be some misunderstanding among medical professionals dispensing the drugs. The Honorable Supreme Court concluded that there was a risk of passing off and that it was a case of dishonest resemblance after reviewing the provisions of the Trademarks Act 1999 and Section 17B of the Drugs and Cosmetics Act 1940. Then comes the famous case of H&M, which is a popular brand. The High Court of Delhi in this case issued a permanent injunction against the defendants H&M, Mega Brands Private Limited and others. In the case of H&M, Hens and Moritz app and another versus H&M Mega Brands Private Limited and others, affirming that prior adoption of a mark overseas can take precedence over prior use of the mark in India. The plaintiff's owner of the globally recognized trademark H&M first registered the mark in United Kingdom in 1985 and subsequently in India in 2005. Now, the defendants began selling garments in India under the name of H&M Mega Brands in 2011 and applied for registration of the mark H&M Mega Brands on April 2014. The plaintiffs sued for trademark infringement and passing off. Now, the defendants argued that their use of logo was legitimate based on the initials of the company directors' names and claimed that the plaintiffs had not entered the Indian market when they introduced H&M Mega Brands in 2011. They also contended that the term Mega Brands and their name sufficiently differentiated their products from the plaintiff's H&M brand. However, the court rejected the defendants' arguments, noting the similarity in the red and white color schemes and the likelihood that the consumers would associate the term Mega Brands with big brand, causing confusion with H&M. Now, H&M Mega Brands is fine, but if you write H&M Mega Brands in the same color combination which H&M has, which is red and white, then obviously it is going to create some kind of confusion in the mind of the consumer. So therefore, the court said that no, this kind of confusion will bring bad name for the H&M and therefore their trademark will be infringed. So they were not allowed to do so. The court emphasized the significance of the plaintiff's prior adoption of the mark in 2005 compared to the defendant's adoption in 2011. The court also dismissed the relevance of the plaintiff's later introduction of goods in India, reasoning that due to increased international travel and cultural exchange, consumers are aware of leading brands worldwide. Consequently, the court prohibited the defendants from using trademark H&M Mega Brands, confirming that in India, prior adoption of a mark abroad can outweigh prior use of the mark within the country. Okay. So then next case is TTK Prestige Limited versus Bagla Sanitary Ware Private Limited and others. In 2021, The plaintiff sued Bagla for trademark infringement of prestige, copyright, and infringement of the prestige logo, passing off, and unfair competition, claiming the defendants were selling products under the plaintiff's registered trademark. An interim injunction was issued stopping the defendants from selling related products under disputed logo. After the defendant's written statement, the plaintiff sought to introduce additional documents, including promotional materials and sales records dating back to 1959, arguing these were discovered later and citing reasonable cause for their delay. The defendants contended this was untimely and in bad faith. The court, emphasizing the Commercial Courts Act's goal to swift case resolution, found the plaintiff lacked due diligence in submitting these documents, which could have been presented earlier. Thus, the court denied the plaintiff's application, noting that extensive documentation had already been submitted and no prejudice would result from this refusal. So in 2021, there's another case. Hershey's Corporation filed an injunction against Atul Jalan, trading as Akshat Online Traders, for selling expired and repackaged Hershey's chocolates, posing significant health risks and damaging Hershey's reputation. The Delhi High Court granted an interim order to seize expired goods and directed the Food Safety and Standards Authority of India to inspect them. The inspection revealed numerous expired Hershey's products with altered packaging, missing FSSAI licenses, and business operation discrepancies. The FSSAI sealed the premises, and further inspections found more expired products with falsified labels. On November 10, 2023, the court authorized officers to seize all expired products and seal the premises of substantial quantities were found, also involving local police, and issuing a non-bailable warrant, later suspended upon assurance of Atul Jalan's attendance at hearings. Despite the defendants' claim of legitimate purchase, the court criticized their lack of due diligence and upheld the injunction, emphasizing the defendants' liability for counterfeit goods and trademark infringement. The case also highlighted a broader issue of systematic sales of expired products on e-commerce platforms requiring urgent attention. Then it is Messrs. PM Diesels Private Limited versus Mrs. Thukral Mechanical Works. The plaintiff, Messrs. PM Diesels Private Limited, registered the trademark Field Marshal on October 16, 1964, with claims of continuous use since May 1963. In 1982, the plaintiff discovered that the defendant, Messrs. Thukral Mechanical Works, was using the Field Marshal mark and issued a cease and desist notice. So cease and desist is a legal notice given by one of the parties whose mark is getting infringed in the market to the other party, saying that you cease and desist from using the mark immediately. Otherwise, I will go and approach the court of law. The plaintiff filed suit number 2408 of 1985 against the defendant. On May 30th, 1986, the defendant acquired the Field Marshal mark from Messrs. Jan Industries, which had initially registered it on May 13, 1965. Now, here the dates are very important. You have to see when the application was registered, when the application was filed. So all these dates are very relevant. But was defunct and did not use the mark. The plaintiff filed a cancellation petition arguing that defendant could not prove continuous use of the mark since 1963. Now, this is also important. If you get a mark registered, you also have to use it. You can't just keep a mark registered and don't use it and just keep it for the sake of it. You have to show that you are also using the mark. So, the Delhi High Court on April 2nd, 2024 ruled in favor of the plaintiff, stating that the defendant failed to demonstrate continuous use of the mark before 1988, while the plaintiff had substantial evidence of continuous use since the 1960s. The court upheld the plaintiff's rights to Field Marshal mark, noting the plaintiff's diligent pursuit of legal actions over 40 years and established goodwill, whereas the defendant's use constituted passing off. The court referenced Supreme Court decision in N.R. Dongre versus Whirlpool and Lyon Laboratories versus Medical Technologies Limited, affirming that subsequent registration does not negate passing off. So I think I have covered all the important case laws here, and we are now in the concluding part of the seminar. So Akshay, if there are any questions, then you can just let me know. If you can see in the chat box, if there are any questions from the viewers, then they can be shared with me.
Yes, ma'am.
So I hope the session was learning and fruitful for all of you who have shown their enthusiasm to attend it, as today is also an important day. Our Prime Minister, Mr. Narendra Modi, is going to take his oath, and also I believe there's a India-Pakistan match going on. So despite all these facts, I am actually cherishing the presence of so many people attending this session, and I really look forward to have these learners in future with us if we come up with an elaborate course on trademark law.
Can we get this presentation copy?